Okay, this is the deposition of defendant Mark Asher, case number 25CV0090122, pending in the United States District Court for the Northern District of Illinois, Western Division. The deposition is proceeding at the offices of the plaintiff's attorney, room 150, Swan Parson, DeKalb, Illinois, pursuant to notice of deposition dated April 2nd, 2025. The deposition is being taken and video recorded on April 5th, 2024, Central Time. Present are the deponent, Mark Asher, counsel for the defendant, Mark Asher, Ms. Sage Randazzo, myself, Anai Escalante, counsel for the plaintiff, Andrews Properties Incorporated. Defending counsel and I have stipulated to some, terms, and I'm going to read them out loud. They're just basic stipulations. Okay, so first one, the remote deposition testimony may be used in this action with the same force and effect as an in-person deposition. The parties agree not to object to the use of the deposition testimony and video recording on the basis that the deposition was taken and recorded remotely. The parties reserve the right to raise all other available objections to the use of the deposition testimony in this action. The parties shall conduct the remote depositions using Zoom. All notices of deposition and non-party deposition subpoenas served in this matter shall describe the remote means of taking the deposition, including A, that the deposition will be taken by remote means, B, that Zoom will be used as a video conference platform, and C, that the deposition will be video recorded. The deposition notices and non-party deposition subpoenas must also otherwise comply with the notice requirements of FRCP 30B and, when applicable, FRCP 45. The noticing party shall reference the stipulated protocol in the notice of deposition or subpoenas. All parties shall endeavor to appear at the deposition from a quiet location to avoid distractions and background noise and to minimize third-party use of the same internet network used for the deposition to maximize bandwidth availability. If the video conference platform used for the deposition has a chat function, the host of the video conference shall disable any chat function, and I have disabled that chat function. All participants must be visible to all other participants at all times during the deposition, and any statements must be made audible to all participants. The deponent and their counsel shall not communicate while the deposition is on the record by text messaging, phone call, email, video conference, chat function, or any other communication medium. The party shall use the following methods for introducing and sharing exhibits for the deposition: the share screen function in the video conference platform or the exhibit sharing platform, if any, agreed to by the parties, to show the deponent any document used at the deposition for impeachment purposes. And in this case, we're using Zoom. Defending counsel and any other counsel that attended the deposition may keep or destroy the documents that were used during the deposition in compliance with any protective order, stipulation, or agreement. Defending counsel shall return or confirm the destruction of any hard copies of documents that were not used during the deposition to deposing counsel and permanently delete any unused electronic documents. The terms herein apply to remote depositions of non-parties under FRCP 45. The subpoenaing party shall attach a copy of the stipulated protocol to a deposition subpoena served on a non-party. Each party is responsible for ordering from the court reporter transcript and video recording of the deposition. All parties bear their own costs for the transcript and video recording. The federal rules of civil procedure and governing laws control all matters not expressly addressed herein. Okay. Mark Asher, you have been sworn to tell the truth by the court reporter, is that correct?
Yes.
Okay. I want to thank you for being here. My name is Anai Escalante. I will be deposing you today. We're here to ask you questions about the civil action brought by Andrews Properties against Mark Asher and the property located at 1000 East Main Street, DeKalb, Illinois. Have you been deposed before, Mr. Asher?
I have not.
Okay. Did you talk to an attorney about this matter at any time before this deposition?
My own attorney.
Okay. Is there anything that will interfere with your ability to testify fully and accurately today?
No.
Please answer fully and correctly. Please make sure that your answers are out loud, no or head nodding. Please say yes or no. And if a question is unclear, you can ask me to clarify and I will do that. Can I assume that if you answer the question that you both heard and understood the question?
Yes.
Okay. And you can let me know if you need a break and we can certainly accommodate that. Just I want to ask that you ask for the break after a question has been asked and answered. So that way we can continue with the next question when you're back.
Yes.
Are you ready?
I am.
Okay. Did you bring any documents with you?
I don't have any physical.
I believe that all the documents that you sent over to me will be like the same ones that we would use to address the topics. So I think that that's all set.
Okay. So besides the documents that I sent you guys, is there any other documents that you want to provide today, Mr. Asher?
I don't think so.
Okay.
But
That's okay. Then I'll start the deposition. Let's see. Can you please state your name, address?
yes, my name is Mark Asher, and I live in I live on Polina Street in Janesville,
What state is that?
Wisconsin.
And what is your occupation?
I'm a contractor that does excavation work.
Okay. Do you own a business or are you an employee?
I own my own business.
Okay. And what state is that in place of business incorporated in?
Wisconsin.
Okay. How many years has this business been running?
I've been doing excavation work for about 3 years.
Okay. What is your education, Mr. Asher?
I just have my high school diploma.
Okay. And do you have any employees in your excavation business?
No, I run it solely.
Okay. And where do you do excavation work?
Just in the vicinity around Janesville.
Okay. And it's Janesville in southern Wisconsin?
Yes, it's about 20 minutes over the border from Illinois.
Okay. So you do excavation work around the Janesville, Wisconsin area. How often do you do work in Illinois?
I don't know. I mean, it just depends on where I get contracts.
Okay. So like in 1 year, how many contracts would you say are in Illinois?
I'd have to go back and look at my books.
Okay. Do you have like an average?
I can't say off the top of my head.
Okay. But obviously you've done at least one, the one in this case.
Yes.
Form. This question is way too broad.
Okay, Mr. Asher, you can continue to answer unless opposing counsel would like you to not answer.
Yeah.
Because
Can you
is
just
it
can you just reform the question into a less broad requirement of information?
yes, so you have performed one job in Illinois that we know of,
Yes, yes,
and that is the job with Annie Andrews Properties.
that is correct.
Okay. And what equipment do you use in your business?
I just use basic excavating equipment to haul away the dirt and to dig up the dirt.
Okay, and what does that include specifically?
I use a backhoe and a truck.
Do you own this equipment?
I do.
Okay. And what is your relationship with plaintiff?
Miss Andrews contacted me to do an excavation job for her.
Okay. And you said you live in Wisconsin, your business is incorporated in Wisconsin. What is your familiarity with DeKalb, Illinois?
I mean, I'm not that familiar with DeKalb.
Have you visited DeKalb before?
I'm sure I have. Yeah.
Okay.
Oh, sorry, that's my huskies.
What is your age, Mr. Asher?
I'm 50.
Okay. So before you were contacted by the plaintiff, Andrews, did you have any knowledge about the land in question, the 1000 East Main Street?
No.
Okay. When you were contacted by Miss Andrews, what did she request?
She asked that I excavate the property at 1000 East Main Street.
Okay, and what was your response?
I agreed and sent her a letter with the cost of excavation.
Okay. And she agreed to your terms?
Yes, she did.
And what were those terms?
The total cost of the job was $47,000, and that included hauling away the dirt.
And excavating.
Yes, and excavating the land as well.
Okay. And what were her terms?
She needed it completed by a date in May.
Do you know what date?
I don't recall off the top of my head.
Okay. What did you request from Miss?
May 15th.
Sorry. Okay.
Yeah,
May
she
15th.
had left a message on April 17th of last year that she received my bid. She needed the work done by the 15th of May, which was fine.
Okay, so she accepted your bid on April 17th, and the term was for $47,000 to be completed by May 15th.
Correct.
Okay.
I did tell her I couldn't get to it this month, the month of April, but would be able after the first week of May. She was agreeable to that.
Okay. Did you ask for any information about the the land?
I got a sketch from City Construction showing that there were no utilities, among other things. And I spoke with Miss Andrews about the property. She'd owned it for 10 years and indicated that it had always been just a blank, an open lot. And I went out to the property itself.
I'm going to refer to plaintiff's exhibit 1. Let me share that on the screen. Okay, are you able to see that on the screen?
Yes, I am.
Okay, can you state for the record what this exhibit is?
That's the site sketch I received of the property. It was prepared by City Construction Company.
Okay, and did you rely on this document in making your bid?
Absolutely, yes.
Okay, and what did this document tell you about the land?
The lot had been surveyed and marked, and the excavation had been surveyed and marked, and there were no utilities in that area.
Okay, and by utilities, what does that encompass?
There were no water lines, there were no electrical lines, anything of that nature was not in that vicinity.
Okay. And is this the only document or information that you gathered to rely in making the contract with Miss Andrews?
No.
What else?
My discussions with Miss Andrews and what she had indicated about the property, as well as I went out to the property myself to check out the dirt.
Okay, and why do you check the dirt?
I checked the dirt to make sure that it is, something I can excavate.
Is there something that would prevent you from excavating?
Sure. I mean, if there was a structure there, or if there was there's a structure there, or there were signs that there was concrete, then that's not something that I could do as an excavator.
Okay, and so you mentioned if there were signs, is there any other indication that you as an excavator would know that there are certain obstacles underground?
With those three things, from your client's representations to my observations and the site sketch, that's what I'm able to use to determine whether or not I'm able to excavate a piece of property.
Okay, and throughout your excavation business jobs, is that typically what you rely on, a excavation report and representations from a potential client?
Generally, yes.
Okay, you don't check anything else before digging?
Generally, no, but it depends on what a potential client tells me about the property as well.
Okay, so you rely exclusively on your client's representations about a plot of land before you excavate?
No, that's not what I said.
Okay, what else do you rely on then?
The other two things that I had mentioned.
And that's it.
In this particular case, yes, based on as well your client's representations.
Okay. What about in other cases? Have you, for example, looked at a deed, like gone out of your way to find out any other information about a plot of land?
Well, generally speaking, my client customer is bringing that to me. I mean, to go and do a prior deed search. What I do is excavation work, and if they want demolition work done, then I would assume that they would say that that's what they want done, and they would provide me documentation indicating that that's what they want, and at which point I can't help them with that.
I'm going to go back to the terms of the contract real quick. You said the plaintiff told you that one of the terms was that you complete the excavation by May 15th, 2024. Did you know why she needed this work done by that date?
I don't recall at this time, but I know she was working on a building project.
Okay. I'm going to share again plaintiff's exhibit number 3. This one. This was prepared by you. Could you explain what this document is for the record?
Sure. So when we receive phone calls, we always do a telephone memo documenting.
And that's okay.
So, and I'm the one who wrote this. I would have written this on April 17th. We talked about when the work needed to be done. I told her, since it would only involved hauling a bunch of dirt away, so we specifically talked about that. It would just involve hauling a bunch of dirt from a vacant lot. It was only going to be a 2 or maybe 3 day job.
Okay. I highlighted the second sentence. Could you read that out loud, please?
Andrew said she found the $47,000 bid for all proposed work acceptable, but needed to get the work done before May 15th. I note here too that I asked her specifically if there were any problems that I should know about. She told me it was just a vacant lot and that she'd owned it for 10 years and she'd never done anything with it. So we talked about it was just hauling away dirt, and I followed up and asked her questions about if there's any problems I should know about. And she specifically said no, and that she told me she owned it for 10 years, meaning she knew the property. So.
Could you finish the second sentence?
Yes. The second sentence, I told her that I couldn't get to it this month, but would after the first week of May.
Okay, so you read the first sentence up to get the work done before 5:15. Could you finish the rest of that sentence?
When the builder was scheduled to start.
Okay, so did you know why she needed the work done by May 15th?
Well, like I said previously, I knew she was going to have something built there.
Okay, so you did know why she needed the May 15th deadline. Is this typically when you do excavation jobs, is it because your clients are going to build
Um, I can't recall all the circumstances
Is that one of the
on all the
circumstances?
jobs. Yeah, absolutely. It's one of the circumstances, sure.
Okay. So you were gonna excavate the plot of land in Exhibit 1. Did you do that, Mr. Asher?
I did what I could.
And what was that?
I completed half the job, and then we ran into concrete, a lot of concrete. And it
Okay.
looked like the gas station had been on the property.
Is it common to encounter obstacles?
I have not experienced that. I've been doing it 3 years, and I've
Okay.
just done excavation work.
Okay, so in the 3 years that you've done excavation work, you've never encountered any obstacles that prevented you from completing a contract?
I can't recall if I never did, but I do excavation work, and that's what I'm hired for. And that's specifically what I talked to Miss Andrews about, hauling away dirt.
Okay, and excavation work does not include hauling or taking out any obstacles underground?
It does not include demolition work of a prior building that had been situated on the lot. No.
Okay. And when you encountered those obstacles, what went through your mind?
In this case,
Mm-hmm. Yes.
I just realized, I couldn't do demolition work, so I reached out to your client and let her know.
Okay. Did you reach out to her that same day?
I can't recall. It was pretty quick. I did reach out to a colleague of mine, Jerry Gunther, who to seek his insight, since I don't recall ever having to deal with a situation before.
Did you contact Jerry Gunther before or after you contacted Miss Andrews?
I believe it was before. Because I believe, I have to see the letter, but I believe I sent her a letter and made reference to Mr. Gunther. Yeah, I did.
Okay. And so you told Miss Andrews that you had encountered that. Did you tell her that you wouldn't be able to complete the job?
Yes.
And do you remember what her response was?
She disagreed.
She disagreed that you could finish the job?
Well, she didn't pay me for the $23,000 plus of work that I did in excavation.
Why did she not pay you?
She wasn't.
Object
You can go ahead and answer.
without knowledge. I don't know.
Okay. I'm gonna rephrase the question. She didn't pay you for the work you had done. Is that because you hadn't completed the work according to the terms of the contract?
No, I had completed what I could according to the terms of the contract. The contract was for excavation. And she sent a letter in response. I can't recall exactly what it said, but obviously she was unhappy. And I had a phone conversation with her before the letter, I believe, too. Because I remember in my notes, I remember when I mentioned that what we found in the dirt, her response was somewhat suspicious.
What made you think it was suspicious?
Well, I asked her why she hadn't told me about it, about all the junk down there. She claimed she didn't know, but she did not sound very believable. I asked her why she hadn't checked with the former owners or building department, and she said she never thought of it, which that just seems odd considering how adamant she was that there were prior, when we were contracting this, that there was nothing that I should be concerned about in the dirt.
Okay.
So she clearly had thought about it, because she told me, no, there's, this lot has been vacant. I've owned it for 10 years. It's just a matter of there's nothing unusual I'll find in there.
Okay. When you found the obstacles, was there anything you could have done to finish the job with the equipment that you own?
No, there was nothing I could have done with the equipment that I have.
Okay. Is there any other way that you could have finished the job?
There's no other way I could have finished the job. No.
So you said you couldn't finish the job because you didn't have the equipment. Is there any way you could have obtained that equipment to finish the job?
I don't do demolition work. I just do excavation work, and that's what I was contracted for. So to complete a job for which I was not hired to do, I didn't. That was not what we had agreed on.
Okay. And you let Miss Andrews know what date that you couldn't finish the contract?
Well, I told her, called her on May 7th and explained the situation.
And you outright told her you can't finish it.
I told her that this was a demolition job, not an excavation job. And I told her that my equipment was for moving dirt and not for demolishing foundations.
Okay. And when was your last communication with the plaintiff?
Well, I had sent her a letter on May 16th. And I think she responded to that. I know she responded to it. I just don't see it here in front of me.
Okay. Did you respond to her after that?
I don't believe so, but if there's a letter somewhere.
Okay, so
It was from May 20th. Sorry.
okay. So she didn't pay you.
Correct.
And you didn't keep contacting her to see if she could pay you?
No, I don't believe so.
Okay. Could you have done anything else to make her pay you?
I could have sued her.
Was an option to impound the plot?
I don't know. I don't know whether there are options. Could have sued her. I guess I could have put a lien on the property.
Okay. And she didn't pay you. Did you think about impounding it?
I don't know what's involved in a property. Right.
This calls for opinion that he's not qualified to give you.
Okay. You can still answer unless it's attorney-client privilege.
I don't know. I don't know what it means to impound a property.
Okay. Okay, that is all my questioning. I'm gonna hand it over to defending counsel if she has any questions.
Yeah, I just wanted to ask you what the custom for excavators are to whether or not it's custom for them to do title checks on projects and job sites, or yeah, if that's part of the custom of excavation.
Not to my knowledge. And particularly in this particular situation where Miss Andrews had made representations to me that the lot had been vacant for 10 years, and specifically that there was nothing unusual that I should be concerned about in the dirt.
And is it part of customs to simply do a soil check, just soil level, not anything underground with an excavation?
I guess it would depend on what representations were made and how adamant they were made about the property.
Okay.
But the work that I do, and I think that I'm known for, is excavation work for the past 3 years, and that's what people hire me for.
Okay, Mr. Asher, you have the right to review the transcript and make any changes you'd like. I want to explain that these changes, you can't change the answers to your questions, but if there's any typos, then you have a right to request those to be changed. Would you like to do that?
I'll defer to my attorney.
Okay. Ms. Randazzo, would you like to waive signature?
Yeah.
Okay. Then this deposition has concluded. Thank you.
Thank you guys. Have a good one.
Yeah, you as well. Best
Thank
of.
you, Mr. Asher.
Oh, of course.